right, we have Jeff Clayton.
Good evening, Mr. Chair, members of the committee. My name is Jeff Clayton. I'm the Executive Director of the American Bail Coalition. I'm not just that, I'm also one of the nation's foremost experts on bail reform, pretrial risk assessments. Recently had published a peer-reviewed piece on this very issue in the UCLA Criminal Law Journal last year, which is worth a read if you have the time. I will tell you that this is the hottest issue in criminal justice right now. You may not pass a bill today, you may not pass a bill tomorrow, but you're going to have to deal with it at some point, and I don't really know what the solution is at this point, other than maybe to go where Representative Marshall is going and say maybe we should just not use them at all. But I don't know the answer to that. What I do know is, in speaking to my wife about this bill, I said, you know, there's a guy up in Wisconsin that said that men are inherently more dangerous as a result of these algorithms, and he found that discriminatory. And my wife chuckled and said, you know, I happen to agree with that because you go out and drink beer with your friends, and so you're much more risky than I am staying home and taking care of your new puppy. But you know, bias in the system is a major problem. Obviously, 110 national civil rights groups have come out saying, don't use these things, and if you do, the main thing that they focused on was validation and transparency. And I think even if you can't get to this question of testing for racial bias and get a solution, don't overlook the transparency part. Like the professor, I have 21 statisticians that I could have evaluate any tool right now, but I can't get there. I can't get the data in order to be able to do that. It's been posited here that this is not a problem in Idaho, but I would posit the opposite, which is you don't know because they haven't been tested yet. And until they are, you won't know. I can also tell you that basing it on the Virginia risk assessment, these are common builders. There's 3 or 4 people in the nation that do this, and I can give you their contact information. They all are built in the same way, with pretty much the same process. I stood shoulder to shoulder in California with 55 civil rights groups to stop the atrocity there, which would eliminate the constitutional right to bail and condition people's release from jail on the results of these algorithms. I went down into a really bad neighborhood, invited in San Diego. As I got closer to the destination, the Uber driver said, "Sir, I think we need to turn around. This neighborhood, it's too dangerous for you to go into." And I said, "I'm going anyway." Around the table were African-American leaders from San Diego, and they said, "Jeff, whatever you do, stop these computers." And I promised them at the time that regardless of where this job went and where I ended up, that I would help expose this as an issue and let people make decisions for themselves, obviously. Transparency, I think, like I said, is the heart and most important piece of this bill, regardless of whether you're able to come up with some solution to racial bias or not. Let academics, let people who are able to do this work do it, because they will. They will if it's transparent. If it's an open source system that can be tested, you'll get the kind of information you want. And so if you don't do anything, do that. Also read Life, Liberty, and Trade Secrets by Professor Rebecca Wexler of Yale University. Read the article and say that it's okay for these people to have black box algorithms and the trade secret protections within cases and stop criminal defendants from understanding it. And is it a problem in Idaho? I think it is, because who can submit a discovery request for the information on which the Virginia tool was built that now the Idaho tool is modeled after? How would any criminal defendant ever get that information and be able to conduct their own research and testing on it? The answer is they can't. Is this a legal issue? Absolutely it is. Read State versus Loomis, a case the US Supreme Court denied cert. The due process issues in that case would make the tools used in Idaho fatally flawed from a due process perspective. And that lawsuit could be filed tomorrow. And certainly, you know, it's not going to be by me, but certainly a criminal defendant who faces a more severe consequence could say, wait a minute, there has to be a due process warning, like in State v. Loomis. Now, let's talk just a little bit about the benefit. It's posited that the benefits of this, regardless if there's bias, simply would outweigh it, and we should proceed forward. Megan Stevenson's a professor of law at the Antonin Scalia School of Law at George Mason University, issued a landmark report discussing risk assessments and practices, and found that not only did they not decarcerate, they increased failures to appear and new arrests while on bail, and did studies of several different states and several different applications of these, and found no evidence that they improve the system or make the system any better. Final point, I guess, and I'll kind of combine my comments there, is it was raised that the federal system would be some great alternative to this. And, while it's been suggested that we're doing some kind of a preliminary strike or something, that's ridiculous. No state is listening to this anymore. And the reason is because the federal system of risk-based preventative detention using these algorithms has increased the pretrial detention rate from 24% when it was passed in 1984 to 72% today. And why? Why is that? And the reason is, if you read Professor Robert Worth from Rice University's recent article on this, he says that these risk assessments, along with the expansion of the penal state since 1970, are the reason why we have generational mass incarceration. And let's think about why that is. Because there's no remorse. There's no healing. There's no nothing, because once you're dangerous, you're more dangerous the next time. You're more dangerous the next time. You're more dangerous the next time. And it doesn't matter. And people realize that when they get, and you're setting them up to fail over time. And that's exactly, I think, what we have happening here. And when the ACLU testified against the Federal Bail Reform Act of 1984, they said, this is wrong to label people as dangerous because no subsequent trial could ever exonerate them. I think it's un-American. I think it's, frankly, un-Christian, because there can be no remorse. And I think embedding these continuously in the system is the reason why we're having all the problems that we have. And I think there was no algorithm prior to 1970, and things were going pretty well back then. And so I would encourage you, again, to, if you can't do anything, just make these things transparent so that you can get the information and that criminal defendants can get the information they need to defend themselves. So thank you for your time.
Representative Ehart.
Mr. Chairman, Mr. Argash, wow, I said it wrong. Taylor. Oh, my goodness.
Oh, it's Jeff Clayton. My name's Jeff Clayton.
Clayton, I'm sorry.
But I can play anybody you want. I can try.
No, I try to keep notes. All I can say is, wow, I could not take notes as quickly as you were speaking, and I would just ask, because your information was hugely relevant, not that everybody else's wasn't, but I think I followed this better. But might it be possible to get a copy of your notes?
Well, yeah, actually, I'll write something up because I don't generally
Never mind.
do that. I was on the debate team in high school and college. That's why I talk so fast. So I will.
You did a good job.
Thank you.
Are there any other questions for Mr. Clayton?
Thank you.
Thank you very much.
Have a great evening. Thank you.